chambers.
Kosovo Specialist Chambers is now in session.
Be seated, please. Good morning and welcome, everyone. Madam Court Officer, please call the case.
Morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Gucati and Haradinaj.
Mr. Howling, any change in your members?
No change, Your Honor.
Mr. Bowden, any change?
Your Honour, no change, and you will see that Mr. Gucati joins us this morning. He was seen by a doctor yesterday evening. He was given additional medication, and he's been seen again this morning by a nurse and given further medication. He's been assessed as being fit to attend proceedings today, but given the advice that if the pain develops during the course of the day, he should notify the trial panel and decisions could be made accordingly. So Mr. Gucati's been given clear guidance by myself this morning that he should do that, and we can to ourselves, and we can relay the information to the trial panel as appropriate.
That's good. Thank you for that information. Mr. Cadman?
No changes, Your Honour, this morning. Ms. Bernabel will have to leave at the first break, and just two very brief matters that I wanted to address.
Thank you. Thank you. Something else?
Just two very brief matters I wanted to address.
Well, let me finish
after
here.
After you've done
We'll
that.
come back to you. Judge Metro continues to appear via Zoom. Good morning, Judge Metro. And we do note Mr. Gucati and Mr. Haradinaj are present in court. Mr. Haradinaj has taken his seat at the witness stand. Mr. Gucati, we're grateful that you're back in court today and hope you are feeling better and more comfortable than yesterday. And we want you to feel free, as before, to stand up if you need to do that. And we hope you can continue with us today.
From Dircho. Thank you very much. Thank you.
The panel wants to hear from the parties on the following plan to deal with the testimony of Mr. Reed. But before we do that, did you have something you wanted to add, Mr. Cadman?
Just very briefly, I've mentioned part of it to the prosecution already. An additional document was put into the presentation queue last night. At that point, we were not 100% certain whether we're going to be using it. I've informed them we will not be referring to that document today. The second point, the addendum to the statement of today's witness was put in, but it was incorrectly put into the Haradinaj presentation queue. I hope that doesn't cause too many difficulties. We can, of course, make sure it's in that witness's presentation queue. That was purely an oversight.
As long as it's filed, we can move it around if necessary or refile it. Thank you.
Yes, and Your Honor, in that regard, we don't see a presentation queue for the next witness to move those documents to.
We'll resolve that this morning.
Okay. Can we proceed? Okay. As I said, we want to, we think we have a way of dealing with Mr. Reed's testimony, which is required by the ruling of the Court of Appeals. That is witness 1253. The witness should make himself, let me go over that, and then I'll ask you if this is going to be acceptable to both, or to all parties. The witness should make himself available on the 24th and 28th of January between 8 a.m. and noon in the Hague time. So that means we will have an early start those 2 days, if necessary. That is 5 p.m. and 9 p.m. local time at the residence of the witness in Australia. The panel knows that the witness has a vaccination plan for the 28th, but this is the only other date available for the witness to testify, so we will expect him to accommodate. This would mean that the hearings on 24 and 28 January will begin at 8 a.m. our time. We will break for half an hour at 9:30 a.m. and we will sit for 2 hours from 10 a.m. until noon, and that will be it for his testimony for those days. I know this will be more difficult for the interpreters and for everyone, but the peculiarities of the situation demand some flexibility on everyone's part. In the best-case scenario, the witness would be heard via video link on both of those days in accordance with Rule 144 and the practice direction for video links. But if the video link cannot be set up by the 24th or by the 28th, the witness will be heard for Zoom on those applicable days. The panel hopes, however, that at least the day of the 28th can have the video link ready for any private session or showing of confidential documents if that is necessary. In any event, the panel directs the parties to share their presentation cue with the witness via the registry. To accommodate such an option, the parties are instructed to send their presentation cues to the registry in due time before the beginning of their examination so the registry can share them with the witness in accordance with the order on the conduct of proceedings. This sharing would happen through secure file sharing tools. The witness would be ordered not to disclose any confidential information from these documents and not to duplicate or share the documents in any form with any third person. And we understand that Mr. Reed is a trained officer and understands these kinds of procedures. So, I'll start with you, Mr. Cadman. Is that going to be an acceptable method of handling this testimony?
Certainly from my side, it is acceptable.
I'm sorry.
Certainly from my side, it is acceptable. Obviously, I will have to consult Mr. Reed. I'm sure he will do whatever he can to accommodate these proceedings. The only caveat that I would put is I don't know whether he's having his vaccine in the morning or the afternoon. I don't know whether he's going to have any adverse effect of that vaccination, but we will accommodate as much as we can, Your Honour.
He's going to have to deal with that. He's the expert. He's going to have to get a changed hour. He's going to have to get a changed hour or something if necessary, because that's what this is all we can provide. Mr. Bowden, anything from you?
It causes no difficulties for our team.
Thank you. And Mr. Holling?
The only issue that we had in Your Honor's proposal is about giving the witness advance notice of the materials that we have before we've even decided whether to use them. Would it be possible to have a small break between the direct and the cross so that materials could be released during that moment?
I don't know if that's possible. They may have to be sent ahead of time, the day before, perhaps, and just you'll have to send everything you might use. Reasonable accommodation is going to have to be made if we're going to get through this.
Understood, Your Honor. To the extent that could be accommodated, that's something that we would be interested in.
Okay, but I need to know if this is going to be acceptable.
Everything else in Your Honor's arrangement is acceptable.
Not everything else. I want to know, can we proceed? Because I'm going to enter an order in about 1 minute.
If it's acceptable, if we can release our materials to the witness during a small break between the direct and the cross. And so if we can present the materials at that moment, then
Okay, you're
everything
asking me
is fine.
something I have no idea about. Mr. Holling, can you help us with the maximum number of documents that you think you might have?
1 moment, Your Honor. About 10.
And these are single sheets? Or do you know?
They're not single sheets, but they're not voluminous documents.
We can accommodate that with probably a half hour to a 45-minute break. And I'll just assume then that that's going to be our backup procedure. We still want to try to get the video links established if at all possible. That's our goal, but we have to have a secondary plan, and that's going to be it. So, given that and your consents, And having heard the parties, I will now render an oral order on the application for video link testimony of the second expert witness, number 1253. On January 7th, 2022, the Court of Appeals panel reversed in part the decision of this panel and allowed the testimony of the second expert witness on a limited basis. On 11 January 2022, in light of the appeal decision and the indication of Mr. Cadman and the witness, or that the witness wishes to testify via video link, this panel indicated that it will rule on the merits of an earlier video link application for this witness. That application was F436. The registry assessment on the feasibility of this video link filing, F467, initially indicated that at least 2 registry staff must travel to Australia, and the complex set of arrangements needed to be put in place before any such link could be operational. The registry also highlighted that due to current travel restrictions in place in Australia and local quarantine requirements, it may not be able to send staff to the location of testimony unless an exemption is granted. This position was updated in court on 13 January when the registry indicated that they are exploring options of setting up video link with the involvement of local authorities only and without the need for registry staff to travel. This opinion, however, also requires significant time to liaise with the competent authorities, send the necessary equipment, find a suitable location, and ensure the required environment for the video link. Mr. Cadman submits that the request for video link is premised on the current travel difficulties, the need of the witness to quarantine upon his return, and his planned vaccination date. The panel notes that the witness has indicated that he cannot travel to the Netherlands between 24 and 31 January, so there is no easy solution in this case. The panel notes that under Rule 144, Paragraph 1, a decision whether to allow video link testimony is within the discretion of the panel, provided that the venue chosen and the available technology meet the requirements under that rule. The panel understands that video link testimony should not be considered only on an exceptional basis. However, the presence in this courtroom of a witness during testimony should remain the preferred option. Accordingly, when deciding whether to allow video link testimony, the panel may consider a number of factors, such as the location, personal and health situation, availability and security of the witness, as well as the complexity and duration of any logistical travel and other arrangements to be made. For the present application, the panel has weighed on the one hand the witness's personal situation, travel difficulties, and stated unavailability to travel to The Hague, and on the other hand, the time it would take to get the necessary equipment to the other side of the world, the arrangements for video link with the assistance of local authorities, the time difference, and the effect this would have on the hearing schedule. The panel has also considered the delays that either of these options could cause and the effect on the right of the accused to be tried without undue delay. In particular, the panel notes that the first hearing day after January is the 21st of February, which would amount to a 3-week delay in finalizing the Haradinaj case only because of the unavailability of one witness. Based on these considerations, the panel finds that the most reasonable option in this case is to have the second expert testify through video link or another form of online testimony. While it is within the discretion of this panel to order the witness to appear in this courtroom in this specific situation, given the traveling from and to Australia is significantly more difficult than with other countries, the panel has opted not to do so. At the same time, the panel acknowledges the complexity of the task before the registry and the minimal amount of time it has to put these measures in place. For this reason, the panel instructs as follows. The witness is ordered to make himself available on 24 and 28 January between 8 a.m. and noon, The Hague time, which is 5 p.m. and 9 p.m. local time, at the place of residence of the witness in Australia. The panel knows that the witness has a vaccination plan for the 28th, but this is the only other date available for the witness to testify, so we expect that he will accommodate. This means that hearings on 24 and 28 January will begin at 8 a.m. our time. We will break for half an hour at 9:30 a.m., and then we will sit for 2 hours from 10 a.m. until noon. I know this will be more difficult for the interpreters and everyone involved, but the peculiarities of the situation demand some flexibility on everyone's part. In the best-case scenario, the witness would be heard via video link on both of these days, in accordance with Rule 144 and the practice direction for video links. But if the video link cannot be set up by the 24th or the 28th, the witness will be heard via Zoom. The panel is mindful that hearing a witness via Zoom departs from the conditions under Rule 144 and the practice direction on video links. However, given the difficulties I mentioned earlier, the parties' stated undertaking to keep private sessions to a minimum, and the delays that any other options will lead to, the panel finds it appropriate to make an exception to Rule 144 in this specific case. The panel notes that this course of action is not being objected to, and the panel is satisfied that the departure from the formal requirements of Rule 144 does not cause prejudice to either party. The panel hopes, however, that at least the day of the 28th can have the video link ready for any private session or showing of confidential documents. In any event, the panel directs the parties to share their presentation cue with the witness via the registry. To accommodate such an option, the parties are instructed to send their presentation cues to the registry in due time before the beginning of their cross-examination, so that the registry can share them with the witness within the time frame provided in the order on the conduct of proceedings. This sharing will be done through secure file sharing tools. The witness is ordered not to disclose any confidential information from those documents and not to duplicate or share the documents in any form with any third person. The registry is further directed to keep the panel informed in the coming days about the progress of the arrangements to be made. This can be done via email or phone calls to our legal officer. The panel is grateful to the registry and the Australian authorities for all their efforts. And this concludes this oral order. And now I have an oral order on the trial schedule. This will deal with our schedule for the next 2 weeks. The panel expects to hear the following witnesses on the following days. Mr. Chalai is witness 1246 today, and if need be, on Monday, 17 January. If Mr. Chalai's testimony finishes today, we will not sit on Monday. Ms. Myers, that is witness 1252, on January 21. If her testimony is not finished on that date, we will hear her on the 24th of January in the regular afternoon session, which will be extended if need be to finish her evidence. Mr. Reed, that is witness 1253, on 24 January and 28 January between 8 a.m. and noon as just ordered. Mr. Gashi, that is witness 1254, on 31 January. And as I stated earlier, the panel expects the parties to notify us immediately through our legal officer in the event any changes become necessary, and we sincerely hope there will be no changes. The panel will also request submissions from the parties in relation to Rules 127, 133, 134, 135, 156, and 159, paragraph 6. An order will be issued probably next week. These submissions will be received in writing or orally once the defense case is closed, and depending on the progress made in the coming weeks. Finally, an oral order on concerning F517 filed by the prosecution on 12 January 2022. This is an SPO notification and challenge under Rule 102, paragraph 3. Given that the filing concerns only one item and that the SPO arguments are put forward in a concise manner, the panel finds it appropriate to shorten the deadline for the response of the defense. The defense is accordingly ordered to respond to F-517 by Thursday, 20 January 2022. No replies will be entertained, and this concludes the third order. Mr. Cadman, you indicated you wanted to re-examine Mr. Haradinaj. Please bear in mind you may be permitted to conduct a redirect examination, but only on matters arising in cross-examination. This is what we said at paragraph 76 of our order on the conduct of proceedings. You may proceed.
Your Honour, may I briefly interrupt?
Sure.
Only to say that my colleague Ms Stevenson will now have to leave at 10:30, so just to make the panel aware.
All right, Mr. Cadman.
Good morning, Mr. Haradinaj.
Good morning.
Suggested in their cross-examination of you that you seek to obstruct this court. Now, to be very clear, is your opposition to this court or to the policy of the prosecution?
My opposition is only to the approach followed by the prosecution, not against the court. The court I see as legitimate, regular.
You have also said in your evidence, and this was challenged by the prosecution, that you want to see all persons prosecuted, regardless of who they are. Why is that important to you?
It is important because I think that everyone that has committed a crime should be brought before justice. Why should they be selected?
To ask you, Mr. Haradinaj, if you are aware of an incident that occurred on the 28th of February to the 1st of March in 1998 in Chires. Are you aware of that incident that concerned the Seydoux family?
Objection, Your Honor. Irrelevant. Goes to new matters on redirect.
Was this mentioned in any way during the direct exam or during cross-examination, Mr. Cadman, your recollection?
The prosecution raised issues related to the conflict during their cross-examination of Ms. Haradinaj. I'm perfectly entitled to put matters to him that concern the same time period.
You're going to have to state your case a little more clearly as to what you're getting at with this.
Certainly, Your Honor, no, and I will do so.
Before the question is asked, please.
Your Honor, I'm going to be referring to a number of incidents that occurred. I want to ask the witness whether he's aware of them. I'm conscious I don't want to give too much information because it's effectively going to predict what...
Are you talking about just incidents, the justness of the war?
I'm asking if he's aware of certain incidents that have occurred as part of the conflict. If the prosecution is allowed to put incidents related to the activities of the KLA, I should be entitled to put incidents to him of which he may or may not be aware of, and whether he is aware that there has been any investigations into those matters.
And, Your Honor,
It goes to the very state of mind and the defence that he has put forward in his evidence and in cross-examination.
we put no such incidents to the accused, and if counsel has a reference to the contrary, we'd be very interested.
Some incident mentioned?
Your Honour, if the prosecution is entitled to put matters to the witness, to the defendant, about activities of the KLA, and whether he supports them, whether he thinks that they should be prosecuted, all I want to put to the witness is whether he is aware of these incidents and whether, to his knowledge, these matters have been investigated.
Well, I don't know what the next question is going to be, but I will state that the justness of the war is not related to the charges in this case. Serbian crimes committed during that war are also not related to this case. If you're asking questions on public interest, we gave you a definition of that and it does not include shedding light on Serbian crimes during the war. It concerns shedding light on improprieties in the context of cooperation between the SITF and the SPO and Serbian authorities. But your client's belief whether any KLA member may have committed a crime and whether that crime could be legitimately investigated and prosecuted by the SITF or the SPO are related to his mens rea and the charges. So that line of questioning from the SPO was legitimate. Yours, if it's going to go to incidents committed by the Serbs, are not part of this case.
Your Honour, I'm not asking him to confirm whether they were committed by Serbs. What I want to put to him is a number of incidents that I'm going to ask him to look at the list of names, and I'm going to ask him whether he believes any of those individuals on that list were involved in the commission of these crimes.
And
That
what
is a
would be
relevant question.
And what would be the basis of his knowledge?
Well, I can ask him if he's aware of that.
All right, I've told you the way we're going to proceed. You can ask a question. Please, Mr. Haradinaj, do not answer until Mr. Holling has an opportunity to interpose any objection that he might have, and then I'll rule on it.
Mr. Haradinaj, are you aware of an incident that occurred on the 28th of February to the 1st of March that has become known as the Chires massacre,
You didn't say a year, Mr. Cadman.
1998, that has become known as the Chires massacre? Before you answer, I'm going to read out a list of dates because the question is the same in relation to all of these dates. On the 1st of April 1999 and on the 25th of May 1998 in two separate incidents known as the Lubinic massacre. On the 15th of January 1999, which has become known as the Račak massacre. On the 5th of March 1999, an attack on Prekaz, in which Serb forces killed Adem Yashari and 60 members of his family. And then on the 27th of April 1999, what has become known as the Meja massacre, in which 300 Albanians are suspected to have been killed by Serb forces. Can I ask you to turn to the list of names?
Excuse me, first you ask him, was he aware of those dates? Let's get an answer to that first. Just yes or no.
With a yes or no answer, Mr. Haradinaj, are you aware of those incidents that I've just read out?
Your Honor, at this point, we would interpose an objection, irrelevant, going to crimes during the conflict, also a leading question, the way that it was phrased by counsel.
I'll take the answer. Did he say yes? Have you answered? Have you answered?
Yes, I am aware. Yes, I am aware.
Now you may ask your question.
Can you look at the list of names, and without mentioning those list of names, can you tell me whether you believe that any of those persons on that list have been involved in any of those massacres?
Objection, irrelevant, goes to matters beyond the scope of cross-examination.
The objection sustained.
In these proceedings, Mr. Haradinaj, you've heard the evidence of a prosecution witness, Ms. Zdenka Pumpa, where she confirmed to this court that the prosecution is not investigating Serbian perpetrator crimes. Can I ask you to confirm how that makes you feel?
Not only myself, but everyone in Kosovo, and I hope not only Albanians, but those who are in favor of justice feel bad, the Serbs and other nationalities, because victims are from all ethnicities.
Can I ask you to confirm that during September 2020, were you aware that any of those incidents were being investigated?
Objection, irrelevant.
Overrule, you can answer that.
Jo, nuk kam.
No, I was not aware. And I still think that no investigation is being conducted.
And Mr. Haradinaj, when you saw those names, some of those names, in the material that you saw in September 2020, how did that make you feel?
Mua më ka kujtu me njëherë drejt
I immediately remember the justice at the time of Milosevic, and I knew immediately that we didn't stand a chance, and I thought that it was politically affected as well, and this is what I felt then. That's why I reacted the way I reacted.
And can you confirm, based on what you've just said, if that was the reason, or if it was it the public interest in what you've just said that caused you to take the action that you've taken?
Objection, leading.
It is leading. Just ask him a question, let him answer himself.
Based on what you've just said, Mr. Haradinaj, and based on what you saw, what was your reason for taking the action that you took?
Zoti avokat.
Mr. Lawyer, whatever I did, and I'm being charged with, and the reason why was only to ensure transparency and public interest, nothing more, and to show how I felt as a veteran and as a member of the public. After all, I have contributed to these people, to democracy, and when I see that they are being violated, that was the incentive why I did it. Transparency and public interest, and the one-sided approach followed by this prosecution office.
The prosecution put to you yesterday that you had published this material. My question to you is, did you publish any of the material that was brought to your offices in September 2020?
Zoti avokat, po vjen.
Mr. Lawyer, I regret to speak to you about this as well, but probably you didn't hear. I mentioned this for 2 days, that never did I publish anything, never did I take photos of these with my phone, of these documents.
Now, yesterday, when you were being cross-examined on that point, there was, well, let me ask you it this way. Do you consider there to be a distinction between publish and publicize?
Po, në varë se në cilë
Yes, it depends on the context that you mention it.
And the phrase that you used, can I ask whether you used the phrase publicize or publish?
Objection, vague. We don't know what context the witness would be saying which of these words.
You might flesh that out a little bit. I'll sustain the objection as asked.
The reference that was put to you yesterday, you used the term in that interview, publicize. Again, do you consider that to be different than publishing?
Your Honor, apologies. Mr. Haradinaj said a lot of things. We don't know what specific video the Haradinaj defense right now is referencing. We'd like a reference.
I'll move on.
You required them to be specific. I think you should
I'll move
do
on.
the same.
I'll move on. Now, The question was put to you yesterday towards the end of your cross-examination about whether you would do this again. Now, let me ask you this. If you were provided with material that you considered was in the public interest, would you do the same again?
That's why I told the prosecutor when he asked me whether I'm going to do that again. I don't know whether these things that happen are in the public interest. If they are, then I consider it my duty as a citizen. That's why when the prosecutor asked me whether I was going to do the same, I can't speak about things that might happen in the future, in 2 years, for example. If it is in the public interest, of course, it is our duty as a citizen. It's a moral obligation to ensure transparency and to protect public interest. I think are obligatory in the moral sense.
Disclose details of witnesses.
No, never, because that's not our job. It's not our duty. For us, it was in the public interest and in our own interest only to speak about what happened, what we received, not what they contained.
Have any further questions for you at this time? Unless the panel has questions for you now.
Microphone, please.
Nothing? Thank you. I believe we're finished. Nothing?
Nothing further, Your
All
Honor.
right. All right, Mr. Haradinaj, you are finished with your testimony. You may take your seat, your previous seat, back in the courtroom.
Thank you.
Mr. Cadman, something you want on the record? Oh, okay. They have to clean the desk up first, so we might as well just sit down and wait a bit.
All I was going to say, Your Honour, is if, I just might need 5 minutes just to reformat the statement because of some of the changes for the next witness, but I can do that whilst this
Yeah,
is
that's
being
fine. Go ahead.
Your Honors, during the transition, there was one small procedural item that if we could put on the record if you would like.
All right, Mr. Holling, you had something?
Thank you, Your Honor. This is in relation to DW 1252, which is the expert witness currently scheduled to testify on 21 January 2022. On the way the trial schedule is unfolding, it's very important that she start and finish that day. We might have objections to the admissibility of certain exhibits depending on whether they are tendered. And in the interest of having that day move as efficiently as possible, we was wondering if the Haradinaj defense could be directed to provide an indication of which of their exhibits they're intending to tender with that witness in advance.
Can you do that, please, Mr.?
We'll indicate by Monday precisely which ones we're going to be tendering.
Excellent. Excellent. Thank you for your cooperation.
And just one point on this statement. It appears that the original statement was in the Gucati presentation queue, so it has a DGH number rather than a DNH number. Yes. I'm just trying to identify what the reference for the Albanian version, just so that we can get it to the witness.
I can help with that, Mr. Cadman. Is the document with the year number DHG0148 to DHG0150.
Mr. Cadman, are you ready?
Yes.
The court usher will bring in the next witness. Mr. Cadman, just a moment. For the witness, the next witness has asked if he could bring his statement. I assume you have a copy of his statement, and he wants to bring notes with him.
Your Honor, we were not notified in advance of any request to bring notes.
No.
We were not provided the notes, as it instead the prosecutor had to do in case a witness
I don't
wanted
think he
to bring
needs the
notes.
notes.
Yeah.
I'm not aware of what notes he wants to bring. So.
I don't either, so we're not going to bring notes in because we don't know what they are. He does not need to bring anything. Mr. Cadman, you can sit down for the time being. Mr. Chalai, you can take your mask off. and put your headset on. Can you hear?
Yes.
Provide you with the text of the solemn declaration that which you will be asked to take pursuant to Rule 141, Paragraph 2 of our Rules of Procedure and Evidence. Please proceed.
Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but the truth, and that I shall not withhold anything that has come to my knowledge.
Be seated. I'll be a while yet, Mr. Cadman. We will deal with his statements as we go along under Rule 154. So, Mr. Chalai, today we will hear your testimony. As you know, Mr. Cadman will go first, and he will ask you questions about your statement and the changes you have made to it. Then the court will issue a brief order regarding your statement and the addendum, and once that is done, the admitted part of your testimony with the changes will be read into the record. Then Mr. Cadman might ask you some other questions if he has any. Next, the lawyers representing Mr. Gucati may ask some questions as well. Then it will be the prosecution's turn. Members of the panel might also ask you some questions. Mr. Cadman estimates that his examination will last 15 minutes. The Gucati defense estimates 30 minutes. The prosecution may take up to 2 hours. The panel may allow re-examination by the defense if the conditions for that are met. Please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat the question or tell them that you don't understand and they will clarify. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. Please also speak into the microphone and wait 5 seconds approximately before answering a question, and speak at a slow pace so the interpreters can catch up. While you are giving evidence in this court, you are not allowed to discuss with anyone the content of your testimony. If any person asks you questions outside this court about your testimony, please let us know. Mr. Cadman, please first ask the witness if his statement with the changes made accurately reflects what he would say in court, and then offer the statement and the addendum for admission. The panel will render an order, and then you can read what is admitted, and we can continue with the examination. You have the floor.
Thank you. Thank you, Your Honor. Can I ask that the Albanian version of the statement is made available to Mr. Chile so he can see that? That is DGH 0150, sorry, 0148. And in the English version, that is DHG 0181 to DHG 0183. Ms. Chile, can I ask you to confirm, if you can see that, whether that is your statement?
I don't have it in front of me.
access it? I do apologise, Your Honour. Your Honour, the addendums were put into the presentation queue yesterday. It's my fault entirely for not checking the actual
So we
statement.
don't have the document?
It doesn't appear to be accessible. We have the, I think it's still in the Gucati presentation queue, but it hasn't been put into this presentation queue for some reason.
Can you clarify which presentation queue of Gucati for which witness?
So we've got the reference to it as DHG. And the reference that Ms. Belici helpfully gave us before we started is the Albanian version. Sorry, not DHG, DGH.
May I ask, is there a paper copy of these?
We'll make a
Is it possible, Vicky, that we have him identify a paper copy and then have that admitted in some way? I don't know what's possible.
No one else will see it.
I know. Somewhere I saw the statement. Where did I see it?
Your Honour, it may take 10 minutes for us to do that.
Okay. We'll step aside. 10 minutes, we'll be back.
I do apologise, Your Honour.
We'll step aside for 10 minutes. We're adjourned.
All right.
Be seated. Ready to proceed?
And just to say the matters are being put into a separate presentation queue as we speak, so they will be available, but we now have copies to be made available to Mr. Chile. I'm grateful for the time, and I'm grateful for Mr. Bowden as well.
And could we take some positive steps that this kind of thing doesn't continue to happen?
We will.
Thank you. I mean, you have a lot of staff here. Somebody can be in charge of this. Go ahead. Thank you for your patience, Mr. Shalai. And am I saying your name correctly? Shalai?
Yes, it's okay.
Okay, thank you. All right, Mr. Cadman, you can proceed.
Thank you. Mr. Chale, can I ask you whether you can now see your statement?
No.
No. Yes.
Can I ask you to confirm that that is your statement?
Mund të konfirmoj që kjo është
Yes, I can confirm that this is my statement.
Turn to the last page of your statement and confirm that that is your signature.
Mund të konfirmoj
I can confirm that this is my statement. That this is my signature, sorry.
The witness be shown DNH 0981, which is the addendum. Can I ask you to confirm, once you're able to see that, whether those are the changes that you indicated should be made to the first statement that you've just confirmed?
konfirmoj.
Yes, I confirm.
Confirm that that is your signature at the bottom of that page.
Është në shkrimi im.
It is my signature.
Your Honour, pursuant to Rule 1, perhaps I should ask one further question. Mr. Chale, can I confirm that that is the evidence that you wish to give before this court today?
Po,
Yes, I confirm that this is the statement I wish to give today.
I confirm that the contents of that statement and that addendum are matters that are true to your knowledge or belief.
konfirmoj që
I confirm that the contents of this statement is true to the best of my knowledge and belief.
5-4, we seek to admit that statement.
Your Honor, thank you. The SPO had previously objected to paragraph 20 to 22 of the original statement. I see now that part of paragraph 22 has been transposed in paragraph E of the addendum with the error number DNH0980. The objection still stands for two reasons. First of all, the paragraphs, as it reads now, it's not intelligible. It starts with, I have requested the same thing, but without the first sentence being in the statement now, it's not clear what the same thing is. And secondarily, on the substance of the paragraph, this witness opinion as to the optimal degree of participation of the Kosovo police to SPO arrest operation is of no relevance to this trial, and the witness is not an expert witness and provides no factual basis for his assertions. Thank you.
Thank you, Ms. Belici. The panel notes that the SPO did object yesterday and has reiterated their objection today to paragraphs 20 through 22. The Haradinaj defense does not wish to rely on these paragraphs, save for the last bracketed sentence in paragraph 22. The panel reiterates its finding in F470 that the evidence of Mr. Chalai appears to be put forth as being relevant to the claim of entrapment advanced by the defense, and without prejudice to the question of the availability of an entrapment defense under the applicable legal regime. The panel considers that the statement and the addendum would be relevant to that issue. In this regard, the panel observes that the last bracketed sentence, as has been pointed out by the prosecution, only makes sense in conjunction with the rest of that paragraph. That's as to paragraph 22. The panel also notes that paragraph 22 loosely relates to what is said in paragraphs 13 and 17 and the statement of the statement, and may for this reason be marginally relevant to these proceedings. For these reasons, the panel rejects the SPO objection to paragraph 22. The panel notes that Mr. Chalai is present in court and available for cross-examination and questioning by the panel. He also attested to the written statement, and the addendum accurately reflect what he would say in court. The panel therefore admits the written statement of Mr. Chalai in evidence under Rule 154, except as to paragraphs 20 and 21. The panel also admits the addendum in its entirety under Rule 154. Madam Court Officer, please assign the exhibit numbers to these items and state them on the record.
Your Honors, the statement DHG 0148 will be exhibit 2D3. And the addendum with number DN80980 will receive exhibit 2D4.
2D3 and the addendum 2D4 are admitted in evidence. Mr. Cadman, I note that the statement contains the address of and some background information on the witness. Do you wish this statement to be nevertheless public, or can you prepare a public redacted version?
We will prepare a public redacted version today.
The Haradinaj defense is ordered to disclose through legal workflow by 20 January 2022 a public redacted Albanian and English version of the statement, so that they can also be recorded as the same exhibits and marked as redacted. The addendum shall be public. There is none of that information in the addendum. Mr. Cadman, you may now read the admitted parts of the statement into the record. Then you can ask any further questions if you have any.
I'm grateful, Your Honour. Mr. Buckley will be reading out the statement.
Thank you. Mr. Buckley, you have the floor.
I'm grateful, Your Honours. The statement reads as follows. I, Rashid Chalai, date of birth 15/08/1968, will say as follows. I was born in Mirash, Ferizaj, Kosovo. I won't read out the address, Your Honour. I've been a member of Kosovo Police from 2000 until the 14th of January 2021. During this time, I held different positions such as patrol officer, shift supervisor with the rank sergeant, officer in operations, police station commander, head of regional operations, deputy regional director, director of the KP operations department, as well as general director of the Kosovo Police. I participated in the KLA. I do not know Mr. Gucati&Haradinaj personally, but he was a public figure, and we all know him as such. No, I have never been summoned as a suspect or witness for interview by the ICTY, OTP, ULEX, or SPO. During the period August 2018 to October 2020, I was General Director of the KP. In relation to the leak of documents from the SPO, I have personally been informed by the Director of Investigations Department in the Kosovo Police, open brackets, because I was out of the country, close brackets, whereas the police, open brackets, investigators, close brackets, of the KP, after hearing from the media that there were documents/files which might pertain to the cases of the prosecution/special court in The Hague being delivered to the KLA War Veterans Association, went to the offices of the association, contacted the officials of the association and met them. In the meeting, the KP investigators were informed that the unknown person/persons have delivered to the offices of this association documents/files that were suspected of belonging to the prosecution/special court in The Hague. This is the reason why the officials of the KLA Association asked the KP investigators to cooperate and proceed/investigate the case and identify the person that kept delivering files to the association offices, as well as to manage these files. Following the request of officials of the KLA Association to the KP investigators to initiate a case related to the files, there was communication with Special Prosecution Office in Pristina whether the Kosovo police should proceed with this and initiate a case related to the files. The Prosecution Office in Pristina said that this case is under the competencies of the Specialist Prosecution Office in The Hague, and that Kosovo authorities cannot investigate this case without a request from the Specialist Prosecution Office in The Hague. There's a typo on paragraph 9, Your Honour. It reads "O body." I'm presuming it's meant to mean nobody. So with your leave, I'll read nobody on that word. Nobody asked the Kosovo police.
Your Honor, my statement reads nobody, actually.
It may simply be a formatting issue on my statement, then, Your Honour.
Go ahead.
Nobody asked the Kosovo police to deal with investigation of this case, whereas regarding the special prosecution, I do not know, and I am not competent to talk about them. We, the KP, received instructions from the Kosovo Special Prosecution Office not to deal with this case. Following the information by the local prosecution office in Pristina that Kosovo police cannot proceed with this case unless the authorities in The Hague request, the Kosovo police stopped collecting information and identifying persons suspected of bringing the files to the association. The CCTV in the surrounding area cannot be expected without a court order. No investigative actions took place because we had not been authorised to take such action by the prosecution. Kosovo police, as per the request of the war associations, increased mobile patrolling in that area during the administrative working hours from 0800 to 1600. I do not know who informed the SPO following the 3 press conferences. As far as I know, nobody from the Kosovo police has ever been present inside the WVA offices or the SPO office in Pristina with the SPO officers. The reason why the KP did not get the documents is because the Kosovo Special Prosecution Office did not authorise us to initiate investigation. The Kosovo police was not inside during the raid, but it provided security outside, open brackets, outer perimeter, close brackets, of the building because the raid was carried out by special units of ULEX and SPO investigators. After the 3rd drop-off of documents, the KP received a request from the war associations to secure their offices, but the KP secures only state buildings of special importance, such as the Office of the President, government, ministries, and some buildings of Serbian Orthodox cultural and religious heritage. I have requested apologies. I think that authorities in The Hague should have engaged the KP to carry out all arrests and raids, because I think that the KP is very professional in carrying out tasks and implementing the law, open brackets. I have requested the same thing from the head of operations of the executive branch of ULEX, as well as the head of ULEX mission, and I have requested that they convey this request to the SPO authorities in The Hague while I was director, close brackets. I am willing to go to court in The Hague to give evidence, and then Mr. Chelai's signature. Your Honour.
Thank you, Mr. Buckley.
Just a couple of questions of clarification, if I may, Your Honour.
Go ahead.
Just to be clear, there is no requirement to read the addendum because obviously the amendments are made to the statement which has been read.
Yes, he made the changes, we understand, yes.
Mr. Chelai, in your statement, you refer to the SBO in Pristina communicating with the Kosovo police. Can you confirm who, to the best of your knowledge, in the SBO communicated to the Kosovo police?
Objection, Your Honor. Could the counsel refer to the specific paragraph?
Paragraph 8.
The investigators who were present at the WVA offices, after the officials of this organization asked them, they initially contacted the Kosovo police through the chain of command, and then they contacted the special prosecutor of Kosovo, the acting special prosecutor of Kosovo, and we received from him the instruction that the Kosovo police cannot investigate this case because this is being investigated by the Specialist Prosecutor's Office in The Hague.
Names of the SBO investigator that you just mentioned. Do you know the name of the investigator who communicated that information?
Of course. I know the name of the investigator and of the prosecutor.
Your Honour, we may need to go into private session so that that question can be answered. I appreciate the difficulties. Perhaps...
You're not going to show anything, you're just going to ask a question. I'm sorry. You're not going to show him anything, you're going to ask a question about a name.
Well, certainly we can have the name written down so we don't know. Well, I would have to ask him if that's the name, if that's the investigator. It puts us in difficulty without me being able to ask the question without prompting the witness.
Judge Ganell, do you still have the transcript coming up?
Yes, I do, Your Honor. One alternative way would be for counsel to ask the witness to write the name himself on a piece of paper.
Yes, yes. That might be the simplest method for you to do.
Putting the list.
Just ask the witness to write the name down.
Yes. Perhaps he could be given a pen and
We need
paper.
a piece of blank paper that we can then mark for identification and admit.
Certainly.
If there's more than one question, have him keep the paper and answer both. Let's leave it
can
with
keep
him
the
for
piece
now.
of paper for the moment. And staying with paragraph 8 of your statement, can you confirm that those persons told the Kosovo police not to investigate?
Në fakt,
In fact, referring to paragraph 8 of my statement, the WVA officials asked the Kosovo police to investigate, so to initiate a case, and then for it to be investigated by the Kosovo police. And the response we got after the consultation of the Director of Investigations with the Special Prosecutor, the answer was that the Kosovo police should not investigate, because this is a competence, this is in the power of a Specialist Prosecutor's Office in The Hague.
Ask you to confirm that the communication that you've just mentioned came from the same names that you've just written down.
po sigurisht.
Yes, of course.
Paragraph 10 of your statement, can I ask you to confirm where you mention the Special Prosecutor's Office giving instructions, was that from the same names that appear on that list?
Po është e vërtetë.
Yes, that's correct. All the instructions that came from the Special Prosecutor's Office were conveyed to our office, to the Kosovo Police, and then we conveyed that to the WVA.
And turning to paragraph 11 of your statement, where you say, following the information by the local prosecution office in Pristina, can you confirm who you mean when you say local prosecution office in Pristina?
I mean the Special Prosecution Office in Kosovo.
And can I ask you to confirm whether the information that you're referring to in paragraph 11 is from the same individuals on the piece of paper?
E konfirmoj.
I confirm that.
And can I ask you to confirm how you came to be aware of that information?
Unë
I mentioned in my statement that from the 7th to the 13th of September, I was on holiday outside the country, I was abroad, but I was informed by the Director of Investigations of all these developments.
Can I ask, on a general level, whether you have had the occasion to work with international forces in Kosovo and outside of Kosovo previously?
unë që nga
From the moment I became a policeman with the Kosovo Police, initially the Kosovo Police was led by the UNMIK mission, and until the last 2 or 3 years, we worked closely with international missions in Kosovo, initially with the UNMIK police in Kosovo, and then other colleagues from the ULEX mission. We also work closely with KFOR forces, which are the military force that is in Kosovo at the moment.
Mind that experience, has it occurred or is it normal for you to be directed not to investigate a matter of this kind?
Ja,
No. Even in the past, in the first years when the Kosovo police was just set up, there were cases when UNMIK police was investigated cases exclusively, because at that time the Kosovo police did not have the capacities to deal with those cases. But from the proclamation of independence and on, it was the Kosovo police that dealt with the cases in cooperation with our foreign colleagues. This was the first time that the Kosovo police did not have any communication whatsoever with the KSC in The Hague.
I'm grateful, Mr. Chile. I don't have any further questions for you.
You need to get that document offered. It needs to be signed. And stated, and dated, and then offered.
Can we see it?
Please show Mr. Bowden, and then Ms. Belici. Vicky?
I will have another question.
Just so everyone knows, they will now scan this into the system. It should be available within minutes. Please assign a number to it.
Your Honor, the document marked by the witness in court will receive Exhibit 2D5. The document marked by the witness in court will receive Exhibit 2D5.
2D5 is admitted in evidence.
I do actually have one final question, Your Honour, if I may. Mr. Chile, having seen the two names written down, just to confirm, they are from the Kosovo Special Prosecutor's Office in Pristina, is that correct?
ja.
No. The first names are the policeman who went to the WVA premises, while the third name is the name of the prosecutor that was contacted in relation with this case.
And to the best of your knowledge, are you aware of who they received those instructions from?
The policeman received the instructions from the director of investigations, who contacted the special prosecutor, the prosecutor from the Special Prosecution Office in Kosovo, and he gave them those instructions.
And can you confirm the date in which those instructions were given?
The instructions were given on the 8th of September 2020.
During this period of time, whilst you were still serving in the Kosovo police, did you have any contact with the Specialist Prosecutor's Office here in The Hague or any member of their staff in Pristina?
Just to clarify, I had several meetings with our international partners, with ICITAP, OSCE, and the leader of the EULEX mission in Pristina, and among the other topics we discussed was the KSC in The Hague, and I always asked whether, if there was a decision of the Kosovo specialist chambers, if they had any decision regarding an arrest or any other matter, the Kosovo police should be engaged, because the Kosovo police is the only institution in the Republic of Kosovo that implements the law, enforces the law and the decisions of the Kosovo courts. So, considering that the office of the specialist prosecutor here in The Hague and the court here are institutions of Kosovo, I asked those things on the basis that they are institutions of Kosovo, and during that time I did not have any contact, not a single contact, no telephone communication, no written communication with them. The only communication that there was one day after Mr. Haradinaj was arrested on the 26th of September, and that was by telephone.
And that was the only contact you had with this office during the entirety of these matters during September 2020?
Yes, I confirm. That was the only contact, and that telephone call was to thank us for the cooperation, offering our assisting them on the 25th, when Kosovo police was called to manage the crowd that has gathered in front of the offices of the WVA.
I have no further questions, Your Honour.
Thank you. Mr. Bowden.
Your Honour, if I could just ask two matters to clarify, please. Mr. Celaj, in relation to the communication, what was that communication? Was it a telephone call, an email? How did that? How was it communicated?
Do you mean the telephone call on the 26th? That was a telephone call.
On the 8th of September, when the communication was made between the Specialist Prosecutor's Office in Pristina and the Director of Investigations. What method of communication was that?
It was a telephone communication, as in other cases. Initially, the police communicates by telephone with the prosecutors, but because this was a very sensitive case, the Director of Investigations contacted the prosecutor, acting prosecutor at the Special Prosecution Office.
Communications were by telephone.
Yes, correct.
I'd also ask you to clarify in relation to paragraph 11 of your statement. The final sentence begins saying, also a few days later, we have been informed that the Specialist Prosecutor's Office in The Hague has authorised investigators of the Specialist Prosecution Office to conduct investigations in relation to this case, and that the Kosovo police should not proceed with this case. Do you know who from the Specialist Prosecution Office, was there a name identified as from the Specialist Prosecution Office in The Hague who'd given that instruction?
I think this was removed by from my statement yesterday, and it's not part of the statement anymore.
You've named one individual who there was communication with at the local office in Pristina. Was there another individual in The Hague who was communicating with the Kosovo police?
I'll repeat again. There was no case when the Kosovo police communicated with any officials here in The Hague, except the 26th of September when I received a call on my telephone.
A few days later you were informed this was by the same individual that you've already written the name down.
Yes, yes.
Thank you, Mr. Bowden. Ms. Bolici? Just for guidance, we'll go to 11:30 and then we'll take a break.
That's fine, Your Honor. Thank you. Mr. Gelai, good morning. My name is Valeria Bolici. I will be putting you some questions. First of all, a fundamental clarification. I would like to show to the witness paragraph 10 of his statement, which is on page DHG0182, which is already on the screen. The statement reads, we, the Kosovo police, received instructions from the Kosovo Special Prosecution Office not to deal with this case. When you say here, Mr. Celai, Kosovo Special Prosecution Office, you are not referring to the SPO, is this correct?
No. I mean the Specialist Prosecution Office of the Republic of Kosovo located in Pristina.
Clarity, Mr. Celai, you are referring to a prosecution office which also goes by the abbreviation SPRK, which has nothing to do with the Kosovo Specialist Chambers. Is this correct?
Yes, that's correct.
In paragraph 11, when you, of your statement, which also reads, following the information by the local prosecution office in Pristina that the Kosovo police cannot proceed with this case, you are referring again to the SPRK, Mr. Celai, is it correct? Not to the SPO.
konfirmoj që nuk
Yes, I am not referring to SPO. I always refer to the SPRK located in Pristina.
Is the same true for paragraph 17 of your statement, which is at the bottom of the page on the HG 0182, and it's in front of you as well in the Albanian version. The reason, when the paragraph reads, the reason why the KP did not get the documents is because the Kosovo Special Prosecution Office did not authorize us to initiate investigation. You are referring to the SPRK, Mr. Cela, is this correct? Not to the SPO.
sakt.
Correct.
To sum it up, is it correct that you never received any instruction from the SPO not to investigate the case concerning the delivery of the documents to the KLA War Veteran Association? Is this correct?
Po e them prap.
Yes, I'm repeating. In no moment, never, did we receive any request by the SPO here in The Hague to investigate or not to investigate this case.
In relation to the three names that you wrote on the piece of paper, without repeating them, please. You told us the first two names are names of Kosovo investigators, and the third name is the name of a prosecutor of the Kosovo Special Prosecutor's Office, Prosecution Office. You are referring to a prosecutor in force at the SPRK. Is this correct? Not to a prosecutor of the SPO?
Sakt.
Correct, correct.
So you received instructions from the SPRK not to investigate the case after the SPRK assessed that it had no jurisdiction, no competence to investigate or prosecute the subject matter. Is this correct?
Sakt.
Yes, correct.
I would like now to refer to paragraph 11 of your statement, and I would like to note the difference between what you initially stated in your statement on the 4th of September 2021 and what you stated at paragraph B of your addendum signed yesterday, which is 2D4. In paragraph 11 of your statement of the 4th of September, 2V3, you stated that you kept collecting information on the materials delivered to the KLA War Veteran Association, also after you received instructions from the SPRK not to collect such information. In paragraph B of your addendum, D2D4, you state that instead you immediately stopped collecting information and identifying persons after you received instructions from the SPRK. Can you explain such a big difference in this part of your statement, which appears to mean exactly the opposite, please?
Yes, I may. In this paragraph, there was a technical mistake, and the word "not" was missing, which of course changes completely the meaning of the paragraph.
I would like to read the first sentence of the last period of the first sentence of paragraph 11, where it reads, so the KP continued to collect information or identify the person suspected of bringing the files to the association, but there was no verifiable information. You add in paragraph 11 of 2v3, also a few days later, we have been informed that the Specialist Prosecution Office in The Hague has authorized the investigators of the Special Prosecution Office to conduct investigation in relation to this case, and the KP should not proceed with this case. You seem to provide quite a great deal of details. You say that you continued investigating after receiving instructions not to, and that the information you collected could not be verified. You also state here that you went back to the SPRK a few days later and you received the same instructions again. So there is quite a great amount of details in the first statement that you gave that it's not fully in accordance with the explanation you just gave us, that there was just one word missing, the word not. Can you explain, please?
The only explanation related to this paragraph is that following the notification by the local prosecution office in Pristina, meaning SPRK, the Kosovo police discontinued collecting information because we were instructed not to initiate the case because the Specialist Prosecutor Office of Kosovo doesn't have the jurisdiction, and that this falls under the jurisdiction of the SPO in The Hague. Regarding the last part of the paragraph that I wanted to be removed was because the information related to the SPO, usually the information was taken from the media. We didn't receive any official information regarding this issue.
Okay. So what you are telling us is that by mere mistake, a lack of attention, you signed the statement where you affirmed that you kept collecting information even when instructed not to do so, but that this is not true. This is your testimony.
Your Honor, I understand the nature of your work, but I'm repeating before the trial panel and before everyone who is following that the Kosovo police, from the moment of receiving instructions from the SPRK prosecutor not to initiate case, not to investigate further this case, because the competence rests with you here in The Hague, with authorities here, I'm repeating, we stopped collecting information and dealing with this case.
Mr. Celai, Your Honor, it's a good time for a break, if you wish, if this was your intention.
And then come back and try to continue. So we will be in adjournment till 12 o'clock.
Rise. rise.
Be seated. Ms. Polici, you may continue. Oh, we don't have the witness. I guess you can't continue at this time.
Thank you, Your Honor. Mr. Celai, in paragraph 7 of your statement that you have in front of you, you stated that the Kosovo police learned from the media that documents had been delivered to the KLA War Veteran Association that might pertain to investigation of the Specialist Prosecutor's Office, SPO. Is it correct that the first information the Kosovo police received was from the broadcasted press conference that occurred on the 7th of September?
Është e vërtet.
Yes, it's correct.
Thank you, Mr. Celai. And is it correct that nobody from the KLA War Veterans Association contacted the Kosovo police between the drop-off of the documents at the KLA War Veterans Association office and the moment when the press conference was held? Is this correct?
Me sa unë kam njëri,
To my knowledge, the Kosovo police was informed from the media and nobody contacted it.
Is it correct that nobody from the KLA War Veterans Association contacted the Kosovo police between the delivery of the second batch of documents on the 16th of September and the second press conference that was held on the same day?
a ka mundësi të përsëri të pyet?
Can you repeat the question, please?
Nobody from the KLA War Veteran Association contacted the Kosovo police between the second drop-off of the documents and the second press conference that occurred on the 16th of September 2020.
Këtë nuk e di,
I don't know that because the Kosovo police from the first case didn't deal anymore with this issue.
Contacted by officials at the KLA War Veteran Association, is this correct?
me sa unë e di,
To my knowledge, no, we were not.
Nobody from the KLA War Veteran Association contacted the Kosovo police between the third delivery of documents at the KLA War Veteran Association office and the third press conference that was held on the 22nd of September 2020.
policia e Kosovës
The Kosovo police received a written request by the WVA and the War Invalids Association and the Association of the Fallen in War on the 6th of October, whereby they asked that the Kosovo police designate 2 police officers to stay in the vicinity of the WVA premises because, as they alleged in this request, following the delivery of the documents by the person or persons, unknown persons, these associations felt in danger and were afraid that some incident might result. So they sent this request to the General Police Director of Kosovo Police, in this case to me.
July, and you referred to the date of the 6th of October 2020. No such request was addressed by the KLA War Veteran Association to the Kosovo Police earlier than that day. Is this correct?
Spakut ndonjë kërkesë e tillë nuk ka
At least at my level, I have no information that such request was sent and received.
Thank you, Mr. Chalai. And you stated earlier that that the Kosovo police investigators attended the KLA War Veteran Association offices on the 8th of September 2020. Was this at the initiative of the Kosovo police that Kosovo investigators went there?
Yes. It was the initiative of the Kosovo police to go to the offices of the WVA.
The KLA War Veteran Association requested the Kosovo police to attend to the offices of the KLA War Veteran Association. Is this correct?
Jo, poliset kanë shkuar.
No, the police went there after getting wind of what happened from the media. They went to the KLA WVA premises and met Mr. Klinako and his staff. And the police were asked, I'm repeating, to initiate what happened regarding the delivery of documents, the first batch.
Thank you, Mr. Chalai. And do you know whether the Kosovo police officers attended the offices of the KLA War Veteran Association before or after the documents that were still in possession of the KLA War Veteran Association had been seized by the SPO?
The serious crime police went to the offices of the WVA after these documents were seized or taken away by the investigators of the SPO.
Thank you. And looking at paragraph 7 of your document, the last sentence, when you say that the Kosovo police received a request as to manage these files, what do you mean in these parts of your statement?
The police investigators who went to the offices of the KLA WVA offices were informed in this case by Mr. Klinako that the only copy they had was seized by the investigators of the SPO here in The Hague. What I did think was that, and the investigators were informed, that some copies were taken by some of the media representatives during the news conference held at these premises.
Also, investigators went to the offices of the KLA War Veteran Association on the 8th of September. Were there any confidential documents still in the premises of the KLA War Veteran Association?
As far as I know, no. There were no other confidential documents there.
You write, when you state that you received a request as to manage these files, what are you referring to?
I refer to the admissions of the officials of this organization regarding the files that were taken by some of the media outlet representatives during the press conference.
And can you explain what was there to manage? What kind of management of files are you referring to? I'm not clear to this point.
You know that if the police were to initiate a case and start investigations into it, in this case regarding the delivery of these documents, at the WVA, one of the first actions would be to seize such files, irrespective of where they were found, of course, on orders by the competent authorities, judicial authorities.
And am I correct that by the time the Kosovo police went to the KLA War Veteran Association offices, the files were already been distributed to the press, or a last copy was seized by the SPO? Was this the understanding of the Kosovo police?
Exact.
Yes, correct.
Since Your Honor.
Thank you. Anything else?
Just two very short points, if I may, Your Honour.
Go ahead.
But very short. Mr. Celai, just to be clear, did the Kosovo police at any stage commence an investigation into these matters?
No. We did not commence any investigations because of the clear instructions we received from the SPRK.
Correct that in order for you to commence an investigation, you would have had to have been instructed by the SPRK.
It is correct. Always bearing in mind that these are sensitive cases, because we as police knew that this was part of the domain of the jurisdiction of the SPO investigators.
You mentioned the communication you received. Can I just ask, the Association of the Fallen in War of 6th of October, is that the name of the organisation?
The request sent to the General Police Director of Kosovo was in the name of 3 organizations related to the KLA: the WVA, the Association of the War Invalids, and the Association of the Martyrs of the War of the KLA.
And the date in which you received that, can I ask you to confirm, was it the 6th of September or the 6th of October?
The correct date when the General Director received this request is 6 October 2020.
It taken some time for it to have reached you as the General Director.
Your Honor, there is an objection, says the question calls for speculation.
No, you can answer the question. Overruled.
Depending on the way the request is sent, I know only that it came to my office on the 6th of October.
That it could have been made on the 6th of September but didn't reach you until the 6th of October.
I don't know. I don't know. But the only thing I can say is that I received it on the 6th of October. I don't want to speculate. But as I said, it depends on the way. The time depends on the way it is sent.
Thank you, Your Honours. I have no further questions.
Mr. Celai, I just want to be clear. I don't want to make you have to repeat yourself, but what day did you actually receive the direction from SPRK not to investigate?
Data är sagt.
The correct date is the 8th of September 2020.
You said that you knew that this was part of the domain of the Special Prosecutor's Office in The Hague. How did you know that?
Shëllësia juaj ne e dim që jemi një polici mjaft.
Your Honor, we are a professional police now. We have acquired 20 years of experience, and it is quite clear to us that everything related to an investigation of the war crimes falling within the jurisdiction of this office is in their domain. And we were not informed. Even now, I know nothing about the content of these documents other than what I learned from the media or from what I followed the proceedings here, Mr. Gucati and Mr. Haradinaj. As Kosovo police, we were very cautious not to be mixed up in other institutions' competences, even though we asked from our international partners, the chief of ULEX mission, to be part of the process, irrespective of what is required from the specialist chambers, knowing that our police are capable of performing all the tasks given to them, knowing that other missions in Kosovo have limited capacities, and knowing also that the Kosovo police love more our country than any other mission that may be present there.
Dealing with the last part of your the questions asked by Mr. Cadman, on this October 6th request that you came to your office, you said you knew you got it on October 6th, correct? Is that a yes?
Exakt.
Correct.
Does it normally take a month for a request for assistance to get to your office when it's filed in the police office?
Po varsisht.
Depending on the way it is sent and who sends it. But in every police station, there is a short way from this any police station to the office of the General Director. It may take several hours.
Thank you. That's all the questions I have. Anything? Anything? Judge Mitro, anything?
No, I'm grateful, Your Honor. No question.
All right.
Microphone, please.
Testimony. Thank you for being with us. You are excused now and may leave the courtroom, and the usher will escort you.
Thank you.
Anything else by anybody for today?
Nothing that Your Honours need to consider immediately, but at the beginning of this week I did have a discussion with Mr. Halling on the question of detention. Now, obviously, Your Honours will be having to consider custody, the next review of custody in due course, as the matter is pending before the appeals chamber, which we haven't received a decision yet. I was asked whether we would agree to a 10-day deferral of you making that decision in order to allow the appeals chamber to make a ruling, as they have done in case 6. And I just indicated that we had no objection to that course of action.
And that then is on the record, and I take it your office can proceed.
Yes, Your Honor, the way we understand it is that because these issues would be relevant for the next detention review, it would run from 10 days from the appeals judgment. Our only question at this point, the Gucati defense did not file an appeal. The appeal has a lot of the same issues common to them, so we would just ask if the Gucati defense wanted detention reviewed on Your Honor's original schedule or this new arrangement.
It would make sense, and we would be content with an amended schedule.
Thank you very much. that will be carried out then, and we will reconvene Friday. What? Yeah. January 21st, 9:30, and we will, the first expert witness will be on deck that day. All right. Anything else? We are adjourned.
All rise.